Hello, and welcome to our program. I'm Krista Rubin, and joining me today is Rachel Pierce. Today's program continues our interactive series of broadcasts on advanced guideline issues, and today's topic is multiple counts. Our goal is to provide you with a greater understanding of the application of the grouping rules found in Chapter 3, Part D of the Guidelines Manual. Using both discussion and real-life fact patterns, we will focus on the analysis required under the grouping rules, and will describe the impact of these determinations on the defendant's ultimate guideline range. Today's program will begin first with a brief review of the introduction behind the rationale for the multiple count rules. Secondly, we will review each rule individually and use fact patterns. And let me note that some of the fact patterns we are using in the broadcast today were those sent in advance to us by you, our audience. So thank you for those. Before we get started though, Rachel, let's talk about some of our housekeeping items.
Sure, Krista. Today you will find a copy of the slides that we'll be using that include the fact patterns that we're going to be talking about today on the FJC's DCN site that you can see now at the bottom of your screen. In addition to the scenarios that we've provided, we strongly encourage you to send your questions about multiple counts to us throughout the broadcast. Now, you can do this by either faxing us the questions during the broadcast, and we'll be showing you that fax number at the bottom of the screen periodically throughout the program. Or you can also email us your questions about multiple counts here to the studio directly at fjtn@fjc.gov. You can use your desktop computer or even your BlackBerry if you would like to do this. And as Krista did mention, we have already received some questions regarding multiple counts, and we're going to try to work some of those in as we talk about our fact patterns today. But again, please continue at any point during our broadcast. If you have those questions, send them to us. You can fax them or email, because we really want to get to those issues that are pertinent to you. We do understand today that we have an audience with a broad range of experience. Some of you have minimal guidelines experience, while others of you have been working with the guidelines for a very long time. We're going to do our best today to ensure that everyone has a working knowledge of the multiple count rules. And of course, as the title states, we'll get to some advanced issues regarding multiple counts as we progress through the broadcast. Let me also remind you at this point that the Sentencing Commission helpline is always available for those of you who have advanced issues that you'd like to discuss with us, or even more basic issues that you'd like a little bit more investigation or clarification on. The Commission's helpline operates Monday through Friday from 8:30 a.m. to 5:00 p.m. Eastern Standard Time. And you can see the helpline number at the bottom of your screen now. Krista?
Well, we're going to begin our discussion today with some background on the multiple count rules. The threshold determination that needs to be made in cases involving multiple counts is to determine if those multiple counts of conviction constitute a single composite harm or separate and distinct harms. As many of you in our audience already know, there are basically two approaches when grouping multiple counts of conviction under the guidelines. Now, one approach addresses multiple counts that involve substantially the same harm. The second approach addresses multiple counts that represent separate and distinct harms. Now, the first approach is the approach that represents multiple counts representing substantially the same harm. It's governed by 3D 1.2, and it's commonly referred to as the grouping rules. And these rules provide a method for determining a single offense level for multiple counts of conviction, again, that involve one composite harm. The second approach involves assigning units for separate and distinct harms, and is a method to incrementally increase offense levels when counts of conviction represent separate and/or additional harms. And this incremental increase, this approach, is found in Guideline 3D 1.4 and is commonly referred to as assigning units. We're going to look at both Guideline 3D 1.2, the grouping rules, and 3D 1.4, the assignment of units, during this broadcast. And as you know, sometimes multiple counts of conviction may involve just the grouping rules under 3D 1.2, or just the assignment of units under 3D 1.4, or sometimes there's a combination of both approaches. And so we're going to talk about all of that today. But before we do, Rachel, why don't you talk about the rationale that the Commission provides in the manual regarding these grouping rules?
Sure. In the introductory commentary to Chapter 3, Part D, we find the rationale that goes along behind these grouping counts, or the rules regarding multiple counts. And basically there are 4 things that these rules address. One is being able to determine a single offense level that encompasses all of the behavior in all the counts of conviction. Secondly, the effort is to limit the impact of formal charging decisions. Thirdly, we want to be able to prevent multiple punishment, or what we often refer to as double counting, for counts that are essentially representing identical conduct. And lastly, in certain cases, we'll need to provide incremental punishment for significant additional criminal conduct or separate harms that are represented by the multiple counts of conviction. Krista, why don't we move on to talk about the rules a little bit more specifically?
Okay, well, and let's pause here for a minute and briefly mention that not all federal offenses, not all types of federal offenses are subject to the grouping rules found in Chapter 3, Part D of the Guidelines Manual. In fact, some are specifically excluded from the application of the grouping rules. Now, as you can see from this slide, Guideline 3D 1.1 tells us that any count for which the statute 1 specifies a term of imprisonment to be imposed, and 2 requires that such term of imprisonment be imposed to run consecutively to any other term of imprisonment shall not be subject to the grouping rules found in Guidelines 3D 1.2 through 3D 1.5. Now, one example of this type of offense is a violation of Title 18, Section 924C, which is use of a firearm in connection with a crime of violence or a drug trafficking offense. Other than offenses that meet the definition for exclusion at 3D 1.1, otherwise all multiple counts of conviction are subject to these grouping rules in Chapter 3, Part D. And to further illustrate this issue, we will have a fact pattern we will get to that addresses 18 U.S.C. violations, and we will get to that eventually. But first, I think we need to walk through the rules individually. So how about you get us started?
Sure, Krista. As Krista mentioned towards the beginning of the broadcast, there are basically 2 approaches to grouping as we or looking at multiple counts of conviction. The grouping rules as laid out in the guidelines at 3D 1.2, and assigning units when necessary as laid out in the guideline at 3D 1.4. And we're going to look at each of these approaches individually. So we're going to first look at the grouping rules at 3D 1.2 that govern multiple counts of conviction that represent essentially the same harm. And 3D 1.2 has 4 subsections, or rules as we refer to them, for the grouping of multiple counts of conviction that do in fact represent substantially the same harm. And that really is something to keep in mind as you're going through the grouping process. When you're looking at your counts of conviction, just sort of step back and ask yourself, are these counts of conviction representing essentially the same type of harm? And if that is the case, then you're going to end up applying the grouping rules at 3D 1.2. And in applying those grouping rules, if you have counts of conviction that fit into those rules, then they are by nature the same type of harm, or the same composite harm. And the guideline actually deems them as such. So let's take a look at our next slide and just look specifically at these grouping rules. You see here, counts that group under Rule A will involve the same victim or the same act. Similarly, but a little bit different, counts that group under Rule B will involve, again, the same victim, this time 2 or more acts constituting a common criminal objective. A Rule C grouping deals with conduct that is treated by a characteristic. And this is either going to be a specific offense characteristic or possibly a Chapter 3 adjustment that might connect these 2 counts and cause them to represent the same harm. And then lastly, Rule D deals with grouping counts of conviction based on some sort of aggregate.
Rachel, let me jump in here and just make mention of an issue critical to the grouping rules. The general approach, as you know, for guideline application is to apply the book in order. Right. And so Guideline 1B1.1 would state that you start at Chapter 1, move on through Chapter 2, 3, etc. However, when we talk about multiple counts of conviction, what we recommend guideline users to do is start with Rule D. Mm-hmm. So we're actually recommending that you start sort of out of order, but there is a method to our madness. On the Sentencing Commission's website, we do have a multiple count checklist that is the recommended process for going through these multiple counts of conviction and applying those grouping rules as well. So the reasons that we suggest looking at Rule D first, the first reason is that approximately 70% of your cases that you deal with on a daily basis will probably group under Rule D. Additionally, when grouping under Rule D occurs when you are first applying relevant conduct. That's the first place in the manual that we actually see 3D 1.2D. Now, this broadcast is not a discussion of relevant conduct, but if you have applied the guidelines correctly, effectively, you have already grouped offenses under Rule D. When you look at the relevant conduct guideline, 1B1.3, and specifically A2 of that guideline, that subsection states that when a guideline is listed as included for grouping under Rule D, these offenses are subject to an additional provision of relevant conduct that we refer to as expanded relevant conduct. Now, expanded relevant conduct allows the court to consider all acts of the defendant and certain acts of others that were the same course of conduct or common scheme or plan as the offense of conviction. These offenses are not limited to the standard time frame of relevant conduct, which is all acts of the defendant and certain acts of others that occurred during the offense of conviction, in preparation for the offense of conviction, or to avoid detection and responsibility for the offense of conviction. So let's talk about then, Rachel, what types of offenses are groupable under Rule D and therefore subject to this expanded relevant conduct?
Well, it's funny, Krista, because sometimes there are places in the guidelines manual where we lay it out very specifically for you. This is how it works. This is what you need to look at. And this is one of those places. As you can see from this next slide, these are the types of offenses that are listed as groupable under Rule D. Again, we're giving you a heads up. These are the types of offenses where we're going to group them under Rule D. And as you've said, all of these offenses are subject to expanded relevant conduct. As you can see from this list, there are a number of different types of offenses, but you can see that they all have something in common. That is, they are guidelines whose offense levels are determined primarily by a total amount of harm or loss, a quantity of substance involved, some other measure of aggregate harm, as with firearms offenses, or the offense in and of itself, that behavior, is ongoing or continuous in nature. On the other hand, as you see from this slide, there is also a list of offenses that are specifically excluded from grouping under Rule D. And as you can see in contrast, these offenses are not ongoing in nature, are not primarily based on harms that can be aggregated, but rather represent separate and discrete harms. So if we get back to the interaction between Rule D and relevant conduct, let's just say that we have 4 counts of distribution of drugs. We know from our guideline list at 3D 1.2 that drug offenses are offenses that are groupable under Rule D. So we're going to be grouping them under Rule D, and we also know that given that type of offense, the court's going to be able to look at all of the conduct that is part of the same course of conduct, common scheme or plan. This allows the court to add together the drug quantities when applying the drug guideline. When we group these 4 counts of drugs together, it's important to remember that we're going to apply one guideline one time. And in fact, the introductory commentary to Chapter 3, Part D specifically says, if the offense guidelines in Chapter 2 base the offense level primarily on the amount of money or quantity of substance involved, add the numerical quantities and apply the pertinent offense guideline for the conduct taken as a whole. So in other words, going back to grouping our 4 counts of distribution of drugs, 2D 1.1 will be applied one time based on the quantity of all the drugs represented in the 4 counts of conviction. Krista, why don't we take a look at our first fact pattern to further illustrate grouping under Rule D?
Absolutely. Our first fact pattern involves 4 counts of fraud. Now, Guideline 2B1.1 is applicable to violations involving some sort of fraud. So we start, we know, by looking at the Rule D list first, and we find there that fraud offenses are in fact included as groupable under Rule D. And you can see on this slide that one application will be warranted for those 4 counts of conviction based upon the same course of conduct, common scheme, or plan. And Guideline 3D1.3b states that if the counts use the same or similar guideline, and if that guideline is included at 3D1.2d, you use the aggregate quantity and combined offense behavior to apply the guidelines as if for a single count application. Now, it's important to also remember that oftentimes unrelated offenses actually may group as well under this particular rule and may actually involve separate and distinct courses of conduct or common schemes or plans as in the offense of conviction. So in your single application, you can see you might be including unrelated offenses as well as these separate and distinct courses of conduct. But of course, it's a single application. Under Rule D, you apply one guideline, one time, based upon all of the conduct, relevant conduct, associated with those counts of conviction. So for example, we have in this next slide a defendant who was actually charged with 7 counts, 3 counts of fraud and 4 counts of theft. Now ultimately, this defendant pled guilty to the fraud 2 and the theft 2 counts. Now the conviction for fraud goes to Guideline 2B1.1, as does a conviction for theft. So we're looking at the same guideline here for these 2 counts of conviction. Of course, 2B1.1 is listed as groupable at Rule D. So when we are applying the guidelines for these 2 counts, the fraud and theft count, we are going to apply 2B1.1 based upon the relevant conduct. It's going to include all of the fraudulent conduct and all of the theft conduct as well. Now, because these offenses are also subject to expanded relevant conduct under 1B1.3A2, the amount of loss from the frauds and thefts that the defendant was not convicted of will be included for application purposes if they meet the definition of relevant conduct as the same course of conduct, common scheme, or plan, which most likely they will. And that is regardless of the fact that these offenses may even have involved separate victims. Right. There is no victim consideration when you're grouping under 3D1.2d. It's not a consideration if there are different victims. We'll get to that rule a little bit later on in the broadcast. So because they use the same guideline, it's listed as groupable under Rule D. You're going to apply one guideline, one time, which is 2B1.1, based upon all of the conduct associated with those counts of conviction. Now, but before we finish our discussion of grouping under Rule D, we need to just clarify a couple of additional issues that sometimes present problems to the users of our guidelines.
Yes, Krista, and this is a common mistake that a lot of users of the guidelines make, and that just because a guideline is excluded from grouping under Rule D does not mean that it's excluded from the grouping process entirely. As a matter of fact, oftentimes when you have an offense that is excluded from grouping under Rule D, you will find that if those multiple counts will in fact group under some of the other rules, A, B, or C. And again, we'll talk about that as we move on. I'd like to show this next slide here. These are a list of offenses that are groupable again at Rule D. These are the guidelines that correspond to those offenses that we showed you earlier. You can see 2B obviously covers the fraud and theft. 2D covers drug guidelines, drug offenses, firearms offenses at 2K2.1, immigration offenses, money laundering offenses, tax offenses. These are all types of offenses that are groupable under Rule D. However, just because they're all listed there doesn't mean they all group together. So if you have multiple counts of fraud, you'll group those together under Rule D. And additionally, if you have in the same case multiple counts of tax offenses, you'll group those tax offenses together under Rule D. Just because they're listed as groupable under Rule D doesn't mean that you will group the fraud and the tax together at Rule D. Unless, of course, you are in the Second Circuit where there are special rules about grouping fraud and tax offenses under Rule D. I would like to highlight the case U.S. v. Fitzgerald at 232 Fed 3rd 315. And again, that's a Second Circuit exception to our general rule of grouping fraud and tax under Rule D.
And so it's not automatic.
Right.
Just because there are guidelines listed at Rule D, and you may have several of them involved in a particular case, it's just not an automatic, oh, well, they group under Rule D because they're at the list. There has to be a meaningful application of one guideline that accounts for all of the behavior represented by those multiple counts. So for example, if you have a count of conviction for drug trafficking under 2D 1.1 and a count of conviction for felon in possession under 2K 2.1, both of those guidelines are listed at Rule D. But there's no way to account for all of that conduct either under application of 2D 1.1 or under application of 2K 2.1.
Excellent illustration. Now let's move on to discuss the application of the other grouping rules. The first thing that we need to address is the difference in the operation of Rule D versus the operation of Rules A, B, and C. As we've discussed, when we're grouping under Rule D, application consists of using one guideline one time. As you can see here, however, the rules or the grouping rules for A, B, and C are a little bit different. And the guidelines require that you apply the guidelines separately to get an offense level for each count of conviction. And what's going to control is the highest of the offense levels that you have calculated. So if we look through another illustration of calculating offense levels, you see for count 1 here, we'll do our Chapter 2 calculations, our pertinent Chapter 3 calculations if there's any victim or role or obstruction adjustments that would apply and come up with an adjusted offense level. We'll do the same thing for our second count. Again, this is grouping under Rules A, B, or C. We'll do the Chapter 2 guideline calculation, and we'll move to Chapter 3 and see if there's any appropriate adjustments that would apply, and then come up with an adjusted offense level. And the comparison between the two is how you're going to determine what the offense level is for the two counts of conviction as we have in this case.
And it's a good illustration, too, of how the guidelines are applied in order.
Right.
As you mentioned, you apply Chapter 2, your Chapter 3 adjustments under Parts A, B, and C, victim, role, and obstruction, come up with your adjusted offense level. You have to do the same for Count 2 because you have to go through the multiple counts before you get to your multiple counts adjustment under Chapter 3, Part D.
Right.
All right, well.
Ready to go on and look at each of the rules?
I am,
Okay.
I am. So we're going to start now and look at Rules A, B, and C individually. We're going to start with Guideline 3D 1.2a. And what 3D 1.2a states is that when you have multiple counts that involve the same victim and the same act or transaction, they are constituting a composite harm, a similar harm. And they will group under this particular rule, under 3D 1.2a. We're going to also look at a fact pattern for grouping under this rule. And in this fact pattern, we have a defendant who's been charged with possession of child pornography and production of child pornography. The facts are that the defendant engaged in sexual acts with a child and took pictures of the activity. The guideline for the possession count is 2G 2.2. The guideline for the production count is 2G 2.1. Now, according to the guideline 3D 1.3, a guideline calculation will need to be done for each count of conviction, as is represented on this slide, and the highest offense level will control. So in the calculation of the possession guideline at 2G 2.2, you can see that an offense level of 35 was the result. However, there was a cross-reference in 2G 2.2 for offenses that involve the production of child pornography. So this particular count cross-references over to 2G 2.1. So the offense level ultimately is 44 because you, in essence, have the same calculation twice. The production of child pornography guideline at 2G 2.1 for this behavior resulted in the offense level of 44. And the bottom line is that that offense level 44 will be the final offense level for this group of counts. Now, I think we can say that as a general rule, where you have one guideline that cross-references to another guideline, and you also have a count of conviction for that cross-referenced guideline, they will group together under Rule A because they inherently involve the same victim and the same act, because they are, in fact, the same calculations. So that's important to remember when you have a guideline that does contain a cross-reference and have an additional count.
And in fact, we actually got a question from our friends in Dallas, Texas, very similar to this fact pattern that we went over. The difference being that one of the counts, rather than possession of pornography, is enticement of a minor, and the second count is the production of the child pornography. So the enticement of the minor, the guideline there, which I believe is 2G 1.3, if I'm correct, also has a cross-reference that would cross-reference in the same way that the possession of child pornography at 2G 2.2 cross-reference over to the production. So it would be the same effect as long as your guideline offense level is higher for that cross-reference, and I believe that's a requirement there at 2G 1.3 as well. So it's the same kind of issue where you're cross-referencing over, and by virtue of cross-referencing, that is in fact a Rule A grouping.
Absolutely. All right, well, let's move on to our next grouping rule.
Sure, Krista. 3D 1.2b is our next rule that we're going to look at. And the guideline says that when counts involve the same victim and two or more transactions connected by a common criminal objective or constituting part of a common scheme or plan, that these counts will then group under Rule B. The fact pattern that we have here for you is we have one count of illegal re-entry into the country. The guideline for that is 2L 1.2, and as you can see from our fact pattern here, we've come up with an offense level of 24. The second count of conviction is a document fraud conviction for which the guideline is 2L 2.2. And so what we have here is a defendant who has illegally re-entered the country and had some fraudulent documents on his person while doing so, getting arrested at the border, of course, and ultimately charged with these two offenses. We do know that 3D 1.3 tells us that we're going to do a separate calculation for each of these counts of conviction. We've done the calculation for the illegal reentry count. The offense level, the final offense level for our document fraud count at 2L 2.2 is a 10. And so the higher of the two controlling, grouping under Rule B, the offense level for these two counts of conviction will be a 24. The guideline tells us, or the guidelines tell us at application note 2 of 3D 1.2, that the term victim is not intended to include indirect or secondary victims, and that generally there's going to be one person who is most seriously affected by the offense and therefore is identifiable as the victim. In some offenses, there aren't going to be such identifiable victims. And you're going to need to sort of take a step back and look at society as large. What is the societal interest that is harmed? And often, and most often, in immigration types of offenses, this is the analysis you're going to be doing. Rather than looking at one person who is most directly harmed and identifiable as a victim, take a step back and look at what sort of societal interests are harmed by immigration offenses. Drug offenses are much the same way. And these types of offenses then will group under Rule B, as the laws that are governing immigration and drug offenses are protecting societal interests.
So let me ask, Rachel. So for example, let's say we have a defendant who is convicted of illegal reentry under 2L 1.2, and also that same defendant harbored aliens. So they also have a conviction that would be represented by guideline 2L 1.1. So the analysis is still going to be the same. When you're looking at who is the victim of these offenses, you have a societal interest that is harmed, and it's the societal interest of the immigration laws. And so therefore we can consider those to be the same victim.
I agree, and I think oftentimes it's probably fair to say that anytime you have some sort of combination of immigration offenses, most likely you're going to be looking at what's the societal interest that's harmed? And it's the societal interest of protecting our country against people who are violating immigration laws. And so I would think in most cases those would group under Rule B.
And you know, one other point before we move on to the grouping Rule C, and that is you had mentioned how similar Rules A and B are under 3D 1.2.
Yes.
Both involve the same victim. Rule A involves the same act. Rule B involves 2 or more acts connected by a common criminal objective. Now, I think sometimes people get bogged down in deciding whether something is the same act or whether it's 2 or more acts. In the example that we gave for the illegal reentry and the document fraud, we suggest that it's groupable under Rule B because we have the same victim, the societal interest of the immigration laws, and 2 or more acts connected by a common criminal objective, the act of illegally reentering and the act of actually being in possession of those fraudulent documents. But I think some would argue that it involved the same act. The defendant walked across the border, illegally reentering the United States in possession of the documents. So I guess what I'm trying to say is there's no need to split hairs and decide, oh, is it A or is it B? Because ultimately, the result is the same.
Absolutely. You have the same victim, and whether you're going to split hairs over it's 1 act or 2, at the end of the day, the end result is the same. That's right.
All right. Well, let's move on to our next grouping rule, and that's found at 3D 1.2c. And what that guideline states is that when one of the counts embodies conduct that is treated as a specific offense characteristic in or other adjustment to the guideline applicable to another of the counts. Now, what that means is that when, in the course of your guideline application, when you're applying Chapter 2 to Count 1, if there is a specific offense characteristic that is the other count of conviction or that represents the conduct of that additional count of conviction, that would warrant a grouping under Rule C. Similarly, if in the course of your regular guideline application for one count, you apply a particular Chapter 3 adjustment, obstruction, for example, and that Chapter 3 adjustment of obstruction represents the additional count of conviction. For example, maybe someone is convicted of drug trafficking and obstruction. When you apply the drug trafficking guideline, you would give an increase for obstruction in Chapter 3, and that would embody the conduct of the additional count of obstruction. So that's what Rule C is getting at. Now let's take a look at another fact pattern for grouping under Rule C. And what we have here is a count of conviction for robbery of a bank, which is governed by Guideline 2B 3.1, and an additional count of assault of the teller. And that guideline is 2A 2.2. Now again, pursuant to 3D 1.3, there will be a separate calculation for each count, and the highest offense level ultimately will control for that group of counts. Now, in the application of 2B 3.1, there's a specific offense characteristic at subsection B3 that addresses injury that occurs during a robbery offense. This specific offense characteristic will represent or embody the conduct or harm associated with the assault count of conviction. That and the fact that the counts actually don't involve the same victim, I want to point out. So the ultimate result is that the end offense level is 24. And the reason that I mention that they do involve separate victims is that I like to think about the grouping rules as a process of elimination. We suggest you start with Rule D. Well, in the example we just gave, both robbery and assault, 2B 3.1 and 2A 2.2 are specifically excluded from grouping under Rule D, which again we know does not preclude grouping under any of the other counts. If we move on then to Rule A would require the same victim. Well, in this fact pattern, the victims are different. The victim for the robbery is the bank. The victim of the assault is the teller. So both Rules A and B do not apply in this particular case. So then moving on to Rule C, we find that we do have a specific offense characteristic that embodies the conduct of that additional count of conviction. So I think it's helpful sometimes to think of it as a process of elimination.
Absolutely, absolutely. So we've made it through a discussion of each of the individual rules at 3D 1.2. And as we can see from this next slide, that takes care of addressing the first approach in dealing with multiple counts of conviction. And again, that is addressing counts of conviction that represent essentially the same or a composite harm. So we'll move on now to discuss the application of the second approach, which is addressing separate and distinct harms, because we know that sometimes multiple counts of conviction do represent separate and distinct harms, and therefore they're worthy of incremental punishment. But again, we've got to get to a single offense level, so there's got to be some way for us to get there. And that's what incremental increases tells us to do. It gives us a process, if you will, to assign units and then ultimately additional offense levels so that we can come up with, at the end of the day, one single offense level for all the multiple counts of conviction. As we see from our next slide, if we have more than one group, and a group can consist of several counts that we've already grouped under one rule, or even a single count could be considered a group for purposes of incremental increases. We're going to compare the offense level of the highest group to the offense level of the other groups, and then we're going to increase the offense level of the highest group according to a guideline table. And you can see here from our next slide, this is the guideline table. The number of units is going to correspond to additional offense levels that will be added to the highest count group. And really the best way to sort of describe this is, of course, with an example. So Krista, could you walk us through an example of this?
Absolutely. We're going to take a look at an example that involves 8 counts of conviction. And this is a good example because it shows you how both of the approaches that we're talking about today can be used in a multiple counts case. So from the slide you can see that we have 5 counts of fraud, a count of robbery, a count of assault, and an additional count of robbery. Now the 5 counts of fraud have already been grouped together as we look through our grouping rules in 3D 1.2, and as you will know from our discussion on grouping under Rule D, these 5 counts of fraud were grouped under Rule D using a single application of 2B 1.1. The offense level for that group of counts is 23. The second group of counts involves robbery and assault of the same victim. These offenses were grouped together either under Rule A or Rule B at 3D 1.2. We have the same victim and either the same act or 2 or more acts connected by a common criminal objective. And then the third count group is a standalone conviction for robbery, and you can see the offense level there is 28. Now, as we are going through our incremental increases, as Rachel mentioned, we're looking at the assignment of units. So we're going to do a comparison of the offense levels of the count groups. And we're going to start off by giving 1 unit to the highest offense level. So in looking at this next slide, which shows guideline, part of guideline 3D 1.4, this is telling us how to assign units. The highest offense level would receive 1 unit. Any offense level that is 1 to 4 levels less serious for a count group would also be assigned 1 unit. Any count group that is 5 to 8 levels less serious than the highest offense level, that would require a half of a unit. And then any count group that is 9 or more levels less serious will not receive any units at all. And this assignment of units, the units really act as a proxy for offense levels, because remember, we are talking about incremental increases. So we're going to increase the guideline because we have separate and distinct harms. So looking at this table, you can see the number of units corresponds to a specific increase. If there's only 1 unit, that wouldn't result in any increase whatsoever. 2 units would be an increase of 2 levels. 3.5 to 5 units would be an increase of 4 offense levels. And that proxy then allows us to account for these separate and distinct harms. So going back to our example involving those 8 counts of conviction, we're going to look at how those units are assigned. The highest offense level is the standalone robbery with a 28. That would be assigned 1 unit. The robbery assault count group with an offense level of 24 is 1 to 4 levels less serious, 4 levels less serious, so that would be an additional unit. And the fraud group with an offense level of 23 is 5 levels less serious than the highest count group offense level of 28. So that would be assigned a half of a unit for a total of number of units of 2.5. Now, we then would go back to 3D 1.4 to see, well, what does 2.5 units equal? And we're telling you here that 2.5 units would be an increase of 3 offense levels. And those 3 offense levels will be added to the highest count group, which is the standalone robbery, of course, which is a 28. When you add the 3 offense levels to that, the combined adjusted offense level for these 8 counts of conviction is a 31. And so we talked not only about how units would be assigned, but we've also given some insight as to how you use both the grouping rules at 3D 1.2 as well as the assignment of units under 3D 1.4.
And this last example is actually a perfect example of that, because I know that, having done this for a long time, you and I both know that most of you out there aren't getting cases involving one single count of conviction, and oftentimes there's 150 counts of conviction, and there's really involved cases that you're looking at. And so oftentimes you're going to have the application of multiple rules. And you start with the process of elimination, and you may be grouping, any number of counts under A or B or D or all of the above. And then at some point, you're going to have to assign units, because again, we have to get to that one offense level at the end of our process.
Exactly. Now, Rachel, we mentioned at the start of our broadcast that the grouping rules will not apply to certain offenses, and that's found in Guideline 3D 1.1. And just as a reminder, 3D 1.1 tells us that a count for which the statute requires a mandatory consecutive term of imprisonment is excluded from the grouping rules. And of course, the best example of that type of offense is a violation of Title 18, Section 924C, using a gun in connection with a crime of violence or a drug trafficking offense. So let's talk a little bit about the impact a 924C conviction would have when you're going through this process of grouping multiple counts of conviction.
It's actually an excellent point, because I know this comes up often. We get this call on the helpline often, and so we wanted to take some time to address this particular issue. In this next fact pattern that we have a defendant convicted of 3 counts, one of which is the violation of 18 U.S.C. 924C. And you see that count off to the side, count 3. The guideline for a violation of 18 U.S.C. 924C is, of course, 2K 2.4. And we already know that the statute requires a mandatory consecutive term of imprisonment. So what we're going to do is we're going to put that count off to the side for now. We're going to talk about, we'll talk about that later when we talk about imposition of a sentence. But for grouping purposes, just go ahead and put that count off to the side. Now, the underlying offense for the 924C in this case is a count of distribution of drugs. And so count 1 is our drug distribution count, with the guideline being 2D 1.1. We also have a count for felon in possession of a firearm. Again, this is a common scenario that we see often in guideline application. So we know we can't group the 924C count with any other count. But the question that remains is, can we group any of the other counts? In this case, can we group the drug count and the felon in possession count? Are we precluded from looking at any sort of grouping of these counts? Well, neither the drug trafficking offense nor the felon in possession offense have the same statutory requirements as the 924C offense, in that they do not require a mandatory consecutive term of imprisonment. You may have a mandatory term of imprisonment with the drug offense, but you don't have the same mandatory consecutive nature required by the statute as you do for a violation of 18 U.S.C. 924C. So again, the question remains, can we at all group these offenses? Well, I'm going to take some time now to discuss a specific offense characteristic and a cross-reference that is found at the felon in possession guideline at 2K 2.1. And I'm sure many of you are aware of this specific offense characteristic and cross-reference. Specifically at 2K 2.1b6, there is a 4-level increase that is provided if the defendant uses or possesses any firearm or ammunition in connection with another felony offense. Similarly, there is a cross-reference at 2K 2.1 that allows for the application of another guideline, and we've already talked about cross-references so far in this broadcast. And the 2K2.1 cross-reference does allow for cross-reference only if the resulting offense level is greater. And the language of that cross-reference is very similar to the language of the specific offense characteristic at B6, in that if any defendant used or possessed any firearm or ammunition in connection with the commission of another offense. Really, the only substantive difference here is that the cross-reference does not require that other offense to be a felony. But otherwise, it's pretty much the same. So really, at the end of the day, the grouping decision is going to come down to whether or not you apply the cross-reference. And so what I mean by that is, if we look at our next example here, if we have a cross-reference that is not applied, and in this example, because the base offense level of the drug calculation is low and lower than the base offense level of the felon in possession, ultimately, we're not applying the cross-reference here. Now, we're not giving an increase for the weapon at the drug guideline, and we're not giving the in connection with another felony offense, specific offense characteristic at 2K2.1B6 because of the 924C. Many of you, I'm sure, know there is specific language at the guideline at 2K2.4 that does not allow you to do that. So, at the end of the day here, we have our offense level for the drug count at 22, and our offense level for the felon in possession at 24. So we know in this instance we're not going to be cross-referencing. So in this case, these two counts, the drug count and the felon in possession count, will group under Rule C. Krista explained earlier in our broadcast that when a count of conviction is basically representing something in that other count of conviction, that is a Rule C grouping. I want to point out here that even though you did not give the increase at 2K2.1B6, that still accounts for, or the increase at the drug guideline for the firearm, that still accounts for that firearm behavior. And so that would be a Rule C grouping.
And it's simply because of the language in 2K2.4 that prevents the application of those specific offense characteristics. Absent the mandatory consecutive penalty for the 924C conviction, those specific offense characteristics would have applied. But we're just precluded from applying those increases because of 2K2.4, what we're instructed to do at 2K2.4.
And not precluded from grouping them under Rule C.
Exactly.
So on the other hand, if we look at this next example, if we ultimately do apply the cross-reference, and you see the difference here being that the base offense level for the drug guideline is higher than our last example, and so we ultimately end up with a cross-reference. And as we talked about at the beginning of our broadcast, when you're cross-referencing over from one guideline to another, essentially you have two guideline calculations at this point for 2D 1.1, and that will result in a grouping under Rule A, which would be the same victim and the same act or transaction.
And sometimes when we get this question, especially when we have the drug trafficking coming out higher, we often get asked, well, why didn't you group those under Rule D? And the answer to that is, well, part of the answer is that when you're grouping under Rule D, you apply the same guideline for those multiple counts. You apply one guideline one time. We haven't done that. We applied 2D 1.1. We then applied 2K 2.1, which eventually cross-referenced us out to 2D 1.1. But if we were to group them under Rule D, we would need to aggregate the quantities. And that just doesn't happen with a cross-reference.
There's no drug quantities in the felon in possession count.
Exactly, exactly. So you end up with two guideline calculations that are the same, and therefore group under Rule A, same victim, same act.
That's right.
Okay, we've covered a lot of information so far in our broadcast, and we're just going to briefly recap what we've discussed before we hopefully have time to get to some of your questions. We've discussed how there are two approaches to grouping multiple counts of conviction. Grouping counts that represent substantially the same harm under Guideline 3D 1.2. And the second approach, assigning units to provide for incremental increases under Guideline 3D 1.4. We discussed the rationale for grouping multiple counts of conviction, the need to determine a single offense level, the prevention of double counting, providing incremental punishment when necessary, and also limiting prosecutorial discretion. We looked at each grouping rule under 3D 1.2 and its operation individually with examples of each. We've discussed the process for assigning units under 3D 1.4 for counts that represent separate and distinct harms and therefore warrant incremental punishment. We've also addressed the fact that oftentimes one case will result in the application of more than one grouping rule and maybe more than one guideline, maybe 3D 1.2 and 3D 1.4. So not just grouping, but also the assignment of units. And then finally, we talked about the impact that a count of conviction that requires a mandatory consecutive term of imprisonment would have on guideline calculation. So we're going to take some time now and respond to a couple of questions that we have. And the first one that we're going to get to involves 3 counts of conviction. The first count of conviction is a drug conspiracy. The second count of conviction is first-degree murder. And the third count of conviction is attempted murder of a different victim than was named in count 2 for first-degree murder. Now, the first-degree murder happened during the course of the drug conspiracy. The attempted murder under 2A 2.1 actually was involved in witness tampering. So it was sort of to avoid detection and responsibility for the offense of drug trafficking. So let's walk through just some guideline calculations and talk about how the grouping rules will come into play. Under count 1, you can see we have a base offense level of 38. There's an increase of 2 for the use of the gun, which would result in an offense level of 40. Now, at the drug guideline, there is a cross-reference. If a victim was killed under circumstances that would constitute first-degree murder, you will cross-reference over to the first-degree murder guideline, which is what we have in this particular case. So count 1, the drug trafficking, cross-references out over to 2A 1.1 for first-degree murder. Count 2 is the first-degree murder, so that is guideline 2A 1.1 with an offense level of 43. And then in our separate calculation of count 3, under 2A 2.1, we come up with an offense level of 30. So by process of elimination, we know that the 2A guidelines are excluded from grouping under Rule D. When we go to our next step, Rule A, do we have any counts that involve the same victim and the same act? Well, yes, because we cross-referenced out of the drug guideline over to first-degree murder and have an additional count for that first-degree murder, they inherently involve the same victim and the same act because they are, in fact, the same calculation. So counts 1 and 2 will group under Rule A. When we look at count 3 for the attempted murder, and as we're going through our process, we know we can't group under Rule D. We also can't group under Rules A or B because the victim of the attempted murder is not the same victim as the victim of the first-degree murder. So we can't group under Rules A or B. We look to Rule C. There's no relevant conduct nexus. There's no specific offense characteristic in the first-degree murder guideline that accounts for the attempted murder in the other guideline. So, so those won't group together as well. So finally then we're left with the assignment of units. We would assign a unit to the highest count group, which would be the first-degree murder, 43. We would look to see if there should be a unit assigned for the third count of attempted murder, and that's an offense level of 30. So it's too far, according to the table at 3D 1.4, to receive an actual unit increase. So the final offense level for that particular fact pattern would be a 43. And then, of course, acceptance applies after the grouping rules.
Right, right. We've covered a lot today, and we are just about out of time. If we didn't get to your questions this afternoon, we apologize. But feel free to call us on your helpline, on our helpline, if we didn't get to those questions, or if you have additional questions, or you're just completely lost and you want some more guidance on how to apply these multiple account rules. Our helpline number is 202-502-4545. If you have a particular topic that you'd like to see us address in an advanced, in a future advanced guidelines broadcast, please don't hesitate to note that on your evaluation form. We thank you for joining us today, and we hope that you have a wonderful afternoon.